My name's Adam Thompson. I'm the President of Doctors of BC for 2026. I want to start by thanking you for taking the time out of your busy schedules to join us tonight for an important topic facing our profession. And I also want to thank our guest speakers from both the College of Physicians and Surgeons and the Health Professions Discipline Tribunal for being here to share their insights and speak with us on this important topic. However, before we begin, I would like to acknowledge that the Doctors of BC offices, where I am zooming in from this evening, are situated on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. For Doctors of BC, us acknowledging the traditional territories is an expression of cultural humility, and this involves recognizing our commitment to support the provision of culturally safe care to First Nations, Inuit, and the Métis people of BC. With that, it is my pleasure to introduce you to Doctors of BC's CEO, Anthony Knight, who will be moderating for tonight's session and guiding us through the discussion. So I'm now going to turn it over to Anthony. Thank you, Anthony.
Thank you, Dr. Thompson, and good evening, everyone. Thank you for joining this webinar. So before we begin, I'd like to note that this webinar is being recorded and will be made available to our members in the coming weeks. All participants are currently muted and the chat function is disabled to minimize disruption due to the volume of participants on tonight's call. For efficiency, please submit your questions through the Zoom Q&A feature located on the Zoom toolbar, most likely at the bottom of your screen. Questions can be submitted throughout the webinar and will be addressed during the Q&A session. When submitting questions, if you could kindly indicate in the question itself the specific panelist or organization you'd like the question directed to. The Health Professions and Occupations Act will fully come into force on April 1st, 2026, replacing the Health Professions Act and introducing significant changes to the regulation of health professionals, including physicians. Today, Doctors of BC is facilitating this webinar with representatives from the College of Physicians and Surgeons of BC and the new Health Professions Discipline Tribunal to help you understand the upcoming changes that are specific to complaints and disciplinary processes under the HPOA. The purpose of this webinar is to provide an opportunity for you to hear directly from and engage with the key organizations responsible for implementing the new disciplinary framework. Before we hear from the college and the Discipline Tribunal, we'll begin with a presentation from Dr. Indavir Mahal, who will provide background, context, and speak to the concerns we've heard from members related to the disciplinary changes and Doctors of BC's broader advocacy efforts on the HPOA. Dr. Mahal is a family physician based in Vancouver and a consultant physician at BC Women's Hospital and Health Centre. She is the chair of Doctors of BC's Council on Health Economics and Policy, which is the physician advisory group to the board on the HPOA. Following Dr. Mahal's presentation, we'll hear from the College of Physicians and Surgeons of BC, Dr. Patrick Rowe, CEO and Registrar, and Graham Kierstead, General Counsel, will speak to the role of the college, clarifying what has changed in complaints and disciplinary processes under the HPOA and how these will function moving forward. Then we'll hear from Benson Cowan, the Director of Discipline for the Health Professions Discipline Tribunal, who will outline the purpose and role of the new tribunal and the importance of populating it with experienced and effective decision makers. Finally, there'll be an opportunity for you to ask our panelists questions following their presentations through a moderated Q&A period. So to get us started, I'll hand it over to Dr. Mahal.
Great, thank you, Anthony. Good evening, everyone. I see there's well over 400 of our colleagues online. Thank you for joining this evening. As you mentioned, I am chair of the Council of Health Economics and Policy at Doctors of BC. I want to start off with the most important part, which is that the HPOA, or the Health Professions and Occupations Act, will fully come into force on April 1st. So we're less than 1 month away and that will replace our well-known Health Professions Act that has been in place for decades. Now, the HPOA represents the most significant reform in the regulation of health professions ever enacted in Canada. And I'm not just trying to use, alarming language. It truly is. It will fundamentally change how physicians and other health professionals are regulated in British Columbia, and there are over 600 sections of the HPOA that we will have to learn. Specifically today, we are going to focus on the upcoming changes to the complaints, investigations, and disciplinary processes under the HPOA, which are key areas that our membership has identified and raised concerns and questions about. Next slide, please. Now, before I get into all the fine details of how we have responded to the HPOA, I want to be clear and transparent that CHEP worked extensively for 5 to 6 years advocating against this legislation. We leveraged every network and resource we had to share our concerns of our physician colleagues against this change. We know that with the tremendous pressures on the healthcare system right now, changing how we are legislated and regulated is not a priority for us. We know there is a crisis in the healthcare system, but it is not a regulatory one. Despite that, the HPOA, of course, it has gone forward despite our objections. And so I'll start off by giving some details and context to the HPOA, including how and when this all started, what our response has been, and our ongoing advocacy to address physician concerns about it. Now, like I mentioned, we have been on this for well over half a decade. Doctors of BC identified this as an issue in 2019 after the Ministry of Health announced possible changes to the Health Professions Act through the release of the Caton Report. The Caton Report was an inquiry into the performance of the BC College of Dental Surgeons, but it also included a second section that explored reforming the Health Professions Act. Now, that report concluded that a complete overhaul of the way health professions are regulated was required to support the delivery of safe care in our province and led to the creation of an all-party steering committee to further guide government's approach. Now, during this time, Doctors of BC provided 2 comprehensive submissions to government outlining our concerns over the lack of details on the proposed changes to the Health Professions Act, and we specifically told government to engage physicians for feedback if they were going to touch that legislation. Unfortunately, on November 24th, 2022, the BC government passed the HPOA, previously known as Bill 36, without absolutely any consultation with health professions. I want to be clear, we support broader intentions to modernize the legislation. Improving Indigenous cultural safety is critical. Addressing discrimination and racism is very important. Increasing the efficiency for smaller professional colleges. And Doctors of BC has been clear that these are all valuable changes. But we've also been very clear that we have concerns over many aspects of the legislative frameworks, including government-appointed boards, changes to the disciplinary processes, the disclosure of minor disciplinary actions, and the removal of appeal of rights. We've also been critical of government for its complete lack of consultation with healthcare professionals when they moved forward with this regulatory reform, and we have continued to advocate for a pause in the further implementation of the HPOA. Now, over the spring and summer of last year, you may remember the college undertook a consultation on its bylaws that needed to be revised to meet the provisions of the HPOA. And therefore, our team at Doctors of BC analyzed over 200 pages of draft bylaws. We compared them with the existing bylaws under the college, and we reviewed the draft bylaws against both the Health Professions Act and the HPOA. That analysis was then communicated back to our membership, and we sought your feedback to inform Doctors of BC's submission to the college. So I've given you a lot of detail there. I encourage you to visit our HPOA webpage under Doctors of BC for further details on our advocacy efforts, including if you want to see our submissions and letter to the government. Next slide, Crystal. So moving on to the focus of the webinar, the intention today is to focus specifically on complaints, investigations, and discipline. And I know for myself and for all of you online, this is one of the most challenging parts of our profession. And these key areas will be drastically different as the HPOA comes into effect this spring. This is an area where our members have raised significant concerns, and some of the details related to how these processes will take place is still emerging. Now, because all the details are not laid out, we understand there is misinformation circulating about what these new processes could look like and will look like, and physicians have a lot of questions. And so therefore, we brought in the college and the Health Professions Discipline Tribunal to ensure you're hearing the right information from the right people, directly from the organizations who will be implementing these processes, and answer questions you may have on the upcoming changes. It's important to keep in mind that complaints, investigations, and discipline are all distinct stages. Ultimately, we want these processes to function at their best and for them to be fair and straightforward for both patients and doctors. As part of our advocacy, Doctors of BC has continuously asked for physicians to be protected from inappropriate complaints that come from health system dysfunction and deficiencies. These complaints do not amount to misconduct, and often they lack scientific and clinical evidence, but the burden they place on physicians is still the same. Being subject to these kind of complaints takes us away from the time we spend on our patient care and has an impact on our mental health and well-being. We have continued to share this to the political influences in investigations and disciplinary matters under the HPOA. Now, the investigation process should have the least imposition on doctors as possible, while ensuring those who need to make decisions are being provided with enough information to support fair and efficient decision-making. Now, when a complaint moves outside to a disciplinary decision, it is important that the process is fair and fosters trust. Those who are appointed to make disciplinary decisions should be specific to those who practice in that medical specialty because they understand the nuances of that clinical practice. Now, as we move closer to April 1st, it's important that you know what changes are coming and feel assured that we will continue to monitor the situation. We will advocate through our ongoing engagement with the government, and our work doesn't stop on April 1st. We will continue to push for the dismissal of frivolous and unfounded complaints and for fair investigation and disciplinary processes with safeguards in place to protect against political influence and interference. Next slide, please. Now, before we hear from other panelists, I do want to acknowledge that the college did not ask for these legislation changes. They are responding to the government's changes, and it is not the college that initiated them. Additionally, the Health Professions Disciplinary Tribunal has been established as part of the implementation of the HPOA. I'd also like to emphasize there is an opportunity to move forward in a more collaborative approach, and that is what we would like. Doctors have told us that an effective regulatory framework is one that supports a healthy and sustainable workforce, one that fosters that coveted patient-physician relationship through clinical independence and professional autonomy. We think the path forward is an approach that honors both public accountability and the expertise of those who deliver care on the front lines, and that includes currently all 484 of you who are online right now. We appreciate the colleges and disciplinary tribunals' willingness to join us today, so thank you for clarifying what is changing in complaints and disciplinary processes and how those processes will function moving forward. Again, thank you for your willingness to participate in this webinar and answer questions from our members. There will be time allocated for questions after we hear from both organizations. And as you listen to the presentations, if you find your questions have not been answered, again, we encourage you to add them to the question box below that Doctors of BC will be monitoring. And with that, I'll hand it over to you, Anthony.
Thank you so much, Dr. Mahal, for providing that comprehensive overview to set the stage for highlighting an opportunity for a more effective path forward that reflects what we've heard from many of our physician members. Our next panelists are from the college. Joining us today are Dr. Patrick Rowe, the CEO and registrar for the college, and Mr. Graham Kiersted, the college's general counsel. Over to you, gentlemen.
Hello, everybody. Thank you. Thanks for the introduction, Anthony. I'm going to begin the presentation and then hand off fairly quickly to my esteemed colleague, Graham, who's Chief Legal Counsel at the college. I suspect many of you have heard me speak on this topic already and are looking for an alternative voice. So I'm going to honor that need, but I'm going to maybe just do a little bit of what you heard from Dr. Mahal is some level setting about where are we, and in particular, what the college sees in the new legislation and some of the principles that we are using in collaboration with the Director of Discipline and his office as we contemplate complaints and discipline in particular. So I'll just get us started. Next slide. We too have a territorial acknowledgement, and the College of Physicians and Surgeons of BC is located on the unceded and traditional territory of the Coast Salish peoples, including the territories of the Hunkamanam-speaking peoples, the Musqueam and Tsleil-Waututh nations, and the Squamish-Nishnam-speaking peoples, or the Squamish Nation. We acknowledge the rights and title of BC First Nations whose territories span across the province. These territories recognize that laws, governance, and health systems tied to lands and waters have existed here since time immemorial. Next slide. So as you heard from Dr. Mahal, there's a piece of new legislation coming into force. Next slide. And that's the Health Professions and Occupations Act, which was passed in 2022 and received royal assent. And in that interval between 2022 and 2026, the regulatory colleges were given some tasks. It's important to recognize that although April 1st is the in-force date for the legislation, some parts of the legislation have been in force already. And it's on the basis of those sections that the superintendent's office was created, that two of the colleges turned into amalgamated colleges. And in fact, that Benson was able to begin his work to stand up the office of the Director of Discipline. So for us at the college, the core role and purpose has not changed. The HPA required us to protect the public. The HPOA requires us to do the same thing. The HPA expected us to do so by using standards of practice and conduct as our measure. The HPOA still requires us to use that measure. The values that we've been using to craft our approach to engagement with registrants and the public in terms of our processes have not changed. And so those values of being evolving, of being accessible, transparent, ethical, dedicated, that is a constancy which will continue after April 1st. Next slide. And as you heard from Dr. Mahal, yes, there was some fairly extensive bylaw consultation. I think it's important to recognize that even before the draft bylaws were distributed for consultation with physicians in the province through our work last year, there was a substantial amount of work over the course of about 2 years, crafting templated bylaws that all of the colleges agreed on and could use, that we, through work with our legal teams and some external legal experts, felt reflected the requirements of the HPOA. So in fact, the draft bylaw process has been about a 3-year process to get us to where we are. It is a complex package, there's no doubt about it. The feedback that we received, both from Doctors of BC and their more formal feedback, but also from individual registrants across the province, and for those of you on the call who did provide that feedback, thank you. We itemized it, we went through it in detail, we cross-referenced it into the bylaws themselves. We recognized even at that stage that there was some confusion, so we began looking for opportunities to engage, and we're obviously grateful that Anthony and Adam and Doctors of BC have given us this opportunity, because there was clear confusion at times about what the bylaws were speaking to versus what the legislation was speaking to. But we were able to navigate through and respond to some of the concerns, and we're able to craft bylaws that are now ready to be presented to the new board. Our new board will be meeting April 1st. That's the first day of the new legislation. They will need to be sworn in with their oaths of office. And once they've constructed themselves and are ready to do work, that same morning, Their job will be to approve the bylaws as well as a number of other items in order to maintain the college's ability to function. Next slide. The HPOA speaks to some guiding principles, and I've listed them here, but I wanted to highlight a few in particular. There's the ones that you know, which is protect the public from harm and discrimination. There's some newer ones, support and promote awareness of reconciliation with Indigenous peoples and with UNDRIP, and to take anti-discrimination measures. The one I really want to highlight, and I think speaks to the concerns that Dr. Mahal was speaking to as well, is that the guiding principles tell us that we have to be fair and transparent, and we have to do this while respecting the privacy of individuals. So those concerns that Dr. Mahal was speaking to, in fact, are specifically itemized in the legislation guiding principles. The legislation guiding principles also ask us to promote holistic healthcare systems. They ask regulators to collaborate. And I think this, in my experience, does reflect some of the concerns that we've heard from physicians over the years, where they felt that they were held to different standards and different outcomes than other healthcare professionals in the system. And I've certainly had colleagues over the years that have expressed that discomfort. The new legislation in the guiding principles essentially says to us as regulators, you need to work together and you need to have processes and outcomes that look similar. So that if a physician goes through the complaints process due to some activity and an outcome is achieved, a naturopath or a chiropractor or a nurse practitioner who goes through a similar complaints process for a similar issue should have a similar outcome. We are specifically told in the HPOA guiding principles that we, the college, must identify and remove barriers to practice. That might be barriers to being able to begin practice, so the licensing process, but that may be other barriers as well. And then finally, the HPOA guiding principles in part 1 speaks to the colleges acting in a transparent manner and providing opportunities for meaningful engagement. I think under Graham and I's leadership at the college, to be honest with you, we're already all about engagement. This is why we're grateful for this participation today. But the HPOA really says to us and other regulators, you must engage, keep engaging, and make sure that engagement is meaningful. Next slide. So, as I was sort of saying, some things remain the same. In the complaints process in particular, the complaints are adjudicated against practice standards and bylaws. And this, as it has been, is a construct that has to occur in consultation with the profession. In other words, practice standards, such as the most recent standard that went out for consultation, involve the profession providing the college feedback, awareness, understanding of whether the standard is appropriate, whether it's applicable, whether it can be actually operationalized in a health system that's in distress. So that work that's been always occurring under the HPA will continue under the HPOA. In terms of the complaints process, there is a requirement for it to be fair and transparent, as I spoke to. There's also a requirement to meet the test of natural justice, and Graham, and I suspect Benson, will speak further to that as well. The external supports that we as a college, in terms of regulating physicians in this province and engaging with physicians through the complaints process, we rely heavily on the external supports that are available to physicians, and that reliance will continue. In other words, we need a strong, healthy relationship and ability to communicate with the CNPA to support them in their work of supporting you. We need a robust and healthy physician health program. We know that complaints often are a symptom of an underlying health issue, or the complaint process can be particularly challenging. And in a circumstance where physicians are in distress, or in moral distress, in time distress, The physician health program is there to really help them through challenging times, challenging processes like a college complaint. And lastly, Doctors of BC. That relationship that we have with Doctors of BC, although we serve different functions within the health system, is an important relationship for us. It allows for the opportunities for things like this, but it also means that at times when complaints come to us about a physician's actions or lack of actions, we need to be able to say to the physicians, have you thought about the following resources at Doctors of BC? We know that Doctors of BC has a vast array of resources, and much like the college, it can be challenging to be certain that all physicians are completely aware of the resources that are available. So those external supports that are available to you, we find critically important as well, and those relationships will continue under the HPOA. Finally, on this slide, we have been hard at work at making sure our processes are human, they're accessible, they're accountable. That is not work that's going to change under the HPOA. Even with the distress of the change, the many unanswered questions that you've sort of heard raised already this evening, we know that that is challenging. We intend to remain accessible, to be as transparent as we can be when we know the answers, and at times when we don't know the answers. Next slide. At this point, I suspect you're ready for a new voice, so I'm going to hand over to my colleague, Graham.
Thank you very much, Patrick. And I will go directly into the next slide. As every good presentation begins with statistics, I'll take you through these. And just these are the stats that were the outcomes from our complaints in the 2024-25 annual report published earlier, at some point last year. But of the key notes to take you to the right column of the matters concluded, well over a half of the 1,200 complaints that were concluded with no criticism whatsoever. They were investigated in a proportionate way, and proportionality is supported by the Health Professions Review Board and by the courts on judicial review. And so those matters would be dealt with largely in a summary fashion. Of the matters that where the inquiry committee would have been critical of 451 of the 1,203, 355, the vast majority of those received advice, so best practice advice or some written criticism, but it would have had no further action after that. Where it starts to get into more engagement would be remediation by consent that could involve an undertaking to refrain from repeating the actions that brought the person to the attention of the college, or to take some kind of an educational course. In only 3 matters was a citation issued, reprimands in 6. I think that if you take a look at those numbers, you can see largely the effectiveness of CMPA at engaging with us to keep matters away from actually having to issue a citation, and those only occur in the most extreme examples of alleged misconduct, because misconduct isn't proven unless it's admitted or goes through a hearing process. But if you add everything up, including the abandoned, withdrawn, and dismissed, about 90% of matters don't proceed any further than either being not critical or getting past the advice and written criticism phase. I can't frankly see that with the HPOA matters are going to be significantly different, although there are going to be some procedural differences in some of the remediations by consent. And the decisions on whether or not to issue a citation will be with my friend Benson, so not with us. And we'll be doing that on a very principled basis, informed by fair process. May I go to the next page, please? Now, I'll be describing the complaint processes going forward under the HPOA, which in many ways are not unlike those which you have potentially had experience with personally. In these ways, the next slides will unpack administrative matters, which are our new construct under the HPOA. some pre-investigation powers, which are also new to us and which are going to be of great benefit. And the investigation committee generally, and some of the competence assessments that it will be ordering. Next slide, please. Now, the authorities of the registrar are where the administrative matters will be found, but the registrar is able to open complaints from any source rather than receiving complaints from the traditional form of filling out a form that we have online or sending in a letter. This is important because there are times when matters come up through media where we might want to be able to engage with it in a way that is defensible, but also allows us to be able to be quick and proportionate in how matters are dealt with. There is also a threshold screening function that the registrar will be performing to conclude matters at intake where they are clearly frivolous or vexatious, or they do not raise a regulatory issue that even if the facts alleged are true, these make for vexatious complaints, which are complaints made for an improper purpose with the intention to harass and nothing to do with protection of the public. Matters that are frivolous, which have no basis in evidence. And that's not an assessment on the merits. That's just, you can see up front that they're not serious or purely speculative. And an abusive process where people try to use our processes to further their goals that would be better served by either going through civil proceedings or some other process, but are coming through to us some workplace disputes and other matters that just don't rise to what would be misconduct, even if they were true. The threshold screening function is much more robust with the HPOA than it was with the HPA. I know that in past, when we have instructed that we would dismiss matters for being frivolous or to say that someone doesn't have standing to bring a complaint, they're complete strangers to the facts, that they weren't a patient, they're just bringing something forward to further a political perspective. The HPRB has ordered them back to us to actually perform an investigation in those. And that's, of course, their right and their role. But it's, I think, encouraging from my perspective that we'll have more of an ability to be able to address matters right when they land in, which frankly does a great service to your members, because then the matters are dealt with conclusively and in a timely way, rather than over weeks or months or potentially even longer. Next slide, please. Now, the administrative matters to which I referred are defined as a breach or a contravention of certain matters. It could be an undertaking that exists as a result of a past matter or practice conditions that were imposed or agreed to. A duty to cooperate with the college on regulatory matters, not everything, but where you are required to do things like CPD to update certain information or to respond to a complaint, and fail to do so despite demonstrable efforts to communicate with you. There can be an administrative matter arising that will be under the jurisdiction of the registrar to be able to deal with it as a summary matter. Maintaining necessary liability coverage, I think we can all see or appreciate why that is a necessity within the medical system. And to practice in facilities that are accredited and not in unaccredited facilities. The administrative matters are not complaints around office management or that kind of matter. Administrative roles of medical directors, that's not what this is for. This is to be able to deal conclusively in a summary process with matters that would have taken us considerably longer and more effort in past without any really appreciable benefit to the process itself or to the people under investigation. A duty to cooperate, to engage with a complaint when received, would previously have required us to essentially, in the middle of an investigation, go to a hearing panel and get an order, potentially, to seek the issuance of a citation, to have a hearing on whether or not someone is engaging and potentially even discipline people for not engaging. It seems that that process is very laborious and does not serve any purpose. It's expensive. And so to bring that exercise of discretion to the registrar to be able to address is more proportionate, allows for a lessening of burdens, because the burden, I think, of having a complaint investigation ongoing for a considerable period of time, it really exacerbates the level of stress and distress that people under investigation will feel. And so for certain select matters, this summary process is available. Next slide, please. The pre-investigation powers to which I referred earlier are really to take a look at, do we have low-risk complaints that may not require a formal investigation? Things like simple allegations of rudeness or dismissiveness within a busy practice. You can see how people might not give much grace to someone who is very busy and is less pleasant than they might be in circumstance. Some office management errors, delayed or incorrect diagnoses, or inadequate physical examinations perceived to be, will be matters that we can take a look at, and they might not require a full formal investigation. And we're looking into an appropriate dispute resolution process that would be early and engaged and supported, that would involve the parties together, not together physically, but to be able to work towards some kind of an outcome with consent that would satisfy them both. Frankly, I think that serves all parties. And if you take a look at a situation where there's a simple misunderstanding, it may be that obtaining a sincere apology will allow something to be able to be dealt with very quickly, and to the satisfaction of the complainant, but also with a very lightened burden on the person under investigation, the subject. Next slide, please. When matters go to the investigation committee, they are going to be inherently more serious. And these are going to be high-risk complaints that require a formal investigation. These will be discrimination of the nature that would be defined through the Human Rights Code, depriving someone of a service or as a result of a prohibited ground, whether it be race or sexual identity or whatever it happens to be, sexual misconduct and sexual abuse, which are separately defined. Competency and competent medical practitioners are absolutely a necessity. These investigation committees will be done in panels composed of licensees and public members, with the authority to take immediate action for the summary protection order to protect the public while a complaint is being investigated. This will be a rare event. We have currently that exact same ability under Section 35 of the HPA. I think we've used it twice because the CMPA is so engaged with us that they will provide the interim undertakings that are requested in order to be able to proportionately protect the public interest, rather than having to go to a public hearing in order to be able to have an interim order that would be published in an outward-facing way. I think you can probably all appreciate that the less publicity someone has for something that is unproven is probably the better. But we have the authority to take that immediate action through summary protection orders, and they are informed by the exact same body of law as were the other interim orders that we currently deal with, which is to say that we are required to take the least invasive measure possible in order to be effective. So you don't go right to suspending someone, you put in a practice condition, and the practice condition itself has to be tailored to the situation. So I'm hoping that you can see that this is essentially the same thing, but with different nomenclature. We also have the investigation committee rather has the authority to ask the director of discipline to issue a citation if they believe that a disciplinary action is warranted. And I know that Benson will be speaking more to that process in a very few minutes. Next slide, please. Now, the investigations committee may order a capacity evaluation if during investigation the licensee is suffering from a health condition or may be. There is a parallel process, however, if people are suffering from a health condition that impacts their ability to be able to practice. That it may be familiar to many of you. It's supported through the physician health program, but our health monitoring program will continue more or less intact in a way that is supportive, that is confidential, and that is really health focused and focused on the whole health of the physician registrant or soon to be licensee of this college or one of your members. The capacity evaluation will happen in if there is a complaint and there is something related to the complaint that is health related. We can separate things out and be able to deal with the capacity evaluation in a separate way. But if someone isn't engaging with us voluntarily, there is the ability to be able to order a capacity evaluation. We have that ability now under the Health Professions Act. We use it sparingly because due to the confidential and supportive nature of health monitoring, most people will become temporarily inactive or to engage with health monitoring, and there is no publication of any of that. It's a completely confidential and supportive process. So that will be continuing as well. But if people don't engage willingly, there is a process now, and there will be a process after April 1st. The Investigations Committee can also order a competence assessment if during the investigation it's determined that they may be lacking in competence. There is a similar process now under skill and knowledge examinations that is currently directed by our board. And instead of being directed by the board, which will have no regulatory involvement in after April 1st, the Investigations Committee will be having skilled assessors review competence if it's determined that that is an appropriate step to take. Next slide, please. So there are, of course, well, there are, I think, 9 people in this country who can make a decision and not have it overturned. We're not any of them. There are abilities to have any matters reconsidered. There a reconsideration or review of a decision or an order. So an own decision can be reconsidered. The registrar's disciplinary order under the administrative matters that I described moments ago may be reviewed by the investigation committee. There is a statutory roadblock at that point after the investigation committee does its review, so there is no further review to the courts as set out in the HPOA. Reconsideration may be requested once within 30 days of the decision or order and on certain specified grounds that the decision or order was made contrary to the act, the regulations, bylaws, or rules, and that the decision or order was not made in accordance with the principles of procedural fairness, and that new information is available, or that new information is available that's material and relevant. So it's not just go back and ask for a different decision. You actually have to have some reasons for requesting it that are material. Next slide, please. Let's find out what this is. So identity protection orders are available. Some of you, I hope all of you, are familiar with duties to report. They exist under the Health Professions Act and will continue under the HPOA. It may be that someone making a duty to report would prefer not to have their identity known to the person about whom they're reporting. And it may be that someone making a complaint about a physician may not want their identity to be known either. So they can apply for have it either partially or fully protected, have their identity done during the complaint process. This will be done in a fair and relatively transparent way, but it does have an implication on exactly how far we can go to resolve a complaint. I think that it's fair to say that you can't, to face an unknown accuser is not going to result in a disciplinary outcome simply because there's no fairness involved in being able to face off against someone who is not going to be able to be cross-examined on what's going on. So they will be granted, I expect, quite infrequently, but they are available to allow for a forum of if not whistleblower protection, but then some degree of comfort to know that it's possible that you can come forward with a complaint and not have your identity known. But it would be pretty much a basic affront to procedural fairness to allow something to go through to a hearing with no witness on the other side. Although I will say this today, since 16, 17 years after the HPA came in, we're still figuring out new things about it or misunderstandings about how it works. So I expect that having a full understanding of all of this on April 1st is an illusion. But our current understanding is what I'm speaking to here. Publication is a matter where we and the Director of Discipline's office and the various health colleges have been working essentially to gain some understanding of what will be published and what is discretionary or will not be. And I will say that I've been working with legal counsel from all of the other colleges to ensure that we have a common understanding of both when something is published and the form in which it will be published, because we want to ensure that we are all doing exactly the same thing and with the same principled underpinnings. We do have the requirement to publish summary protection orders. We have currently a requirement to publish interim orders through Section 35 of the HPA. We also currently are required to publish disciplinary orders. We are not currently required to publish requests for citation, and we'll be working on exactly what the parameters of those are. But that's a very narrow group of matters to be published. Some orders are excluded when the subject physician consents to an outcome. That would be excluding sexual abuse and discrimination. Those are going to be fairly extreme outcomes. Discrimination here, again, is not the kind of discrimination, the sort of a micro-invalidation or a microaggression in relation to someone with a protected ground. This is actually the kind of discrimination that you would find through the Human Rights Tribunal. And the working group with Director of Discipline and Health College Legal Counsel have been working to ensure consistency and alignment in our processes. And we're looking at balances between, of course, transparency and confidentiality, because we have to respect the legal precepts around the balance of probative value and prejudice to the individual about whom publication happens. Next page, please. Duties to report, I touched on these a bit earlier, but some specifics here. There is a duty to report from a regulated health professional to the college of any other regulated health professional if they believe that that person is a significant risk to the public. So a reasonable belief that their continued practice would pose a risk to the public. There's also a duty to report sexual misconduct, sexual abuse, and discrimination. And that will be we're developing reporting standards on that, but they are very similar to the HPA. Discrimination is new. Query whether or not identified discrimination would have always been a risk to the public, however. And we are currently today, I'm updating our duty to report guide. It will be, I believe, published on our website. Next slide, please. We are developing and we'll be rolling out support programs for certain complainants, information services for all, frankly, about what their rights and obligations are on how to make complaints. There will be support workers being contractors retained to assist complainants through the process. And for some matters, when they become more severe, we will have counseling services available to support a person in recovery from sexual misconduct, sexual abuse, or discrimination. There is an application process, an adjudication process for these with appeals, of course. And there are metrics for qualification for support workers and support services. And that will be made transparent as well. Next slide, please. Discipline and disciplinary matters. Now I'm leaching into your territory and I'm feeling badly for that. We no longer have a discipline committee effective April 1st or have disciplinary hearings. This will be probably a relief to our disciplinary committee of years gone by because we periodically would assemble them to do interim things, and they haven't done a hearing in quite some time. But the director of discipline will be conducting the hearings of the office there. We will continue to prosecute, and we will be involved in settlement negotiations and case conferences and all kinds of other things that are very familiar to anyone who's been involved in a process like this. Our request for citation may be made by the investigations committee to the director of discipline, who will be setting a specified time to reach consent agreement after a citation is authorized, and must review and approve some consent dispositions for matters alleging sexual abuse or sexual misconduct and others. And next slide. I'm not sure there is a next slide. Nope, there isn't. There we go. Next slide is a series of graphics.
Well, thank you so much, gentlemen. Appreciate your willingness to present tonight. Thank you, Dr. Rowe and Mr. Kirsten. I'd now like to introduce our next presenter, Mr. Benson Cowan, who is the Director of Discipline for the new Health Professions Discipline Tribunal. This tribunal sits under the broader Health Professions and Occupations Regulatory Oversight Office that has been established under the HPOA. Over to you, Mr. Cowan.
Thank you. If we just go to the first slide. So I will try and be brief. I mean, Graham took a bit of my time and a bit of my subject matter, but I'll get over that. I'll try and work through this fairly quickly, so there's plenty of time for questions. I won't get into the whole details of our territorial acknowledgement, other to say that I'm coming to you from Victoria, which is the traditional territory of the Lekwungen-speaking peoples, including the Songhees and Esquimalt. And I live in the area covered by the Douglas treaties that were agreed upon in the 1850s. Next slide, please. So, as has been pointed out by the previous speakers, April 1 is the date in which the HPO becomes fully effective. My part of that is that at that point, the tribunal takes over responsibility for its part of the discipline process. The tribunal we're housed in the office of the superintendent. We are independent and impartial, and we oversee a number of different aspects of the process. Some of them are overseen by me in the capacity of my role as a statutory decision maker, and the heart of the process, the hearing process, is done by a discipline panel that are appointed by me. The members of the tribunal are not appointed by the government. They're not appointed by cabinet. They're appointed directly by me through a merit-based process. Dr. Roque showed some of the principles of the HPOA, and those guide our work, including of particular importance to the tribunal: respects for the principle of procedural fairness, the protection of the public from harm and discrimination, supporting and promoting awareness of reconciliation, UNDRIP, and Indigenous specific anti-racism measures, and reflecting the public interest generally in throughout the discipline process. Next slide, please. A bit of background about myself. I've been in this role since September 2024, and as I referenced, I'm, as an individual decision maker, responsible for some decisions under the Act, and I'm a settler of Irish and French Canadian heritage. I was born and raised in Northern Ontario and Manitoba, with longstanding ties to the Ottawa area. I've been in BC for almost 5 years. Prior to my appointment, I worked as a constitutional and administrative litigator with the Ministry of the Attorney General. Prior to that, I worked as the CEO of Nunavut Legal Aid, and in years prior to that, I worked in the tribunal world in Ontario with a couple of clusters of tribunal. I've done a bunch of different work on justice sector reform, but I started out as a criminal and constitutional litigator in Toronto. Next slide, please. I'd say that in terms of my background, one of the things I like to highlight, sometimes to avoid having to explain it, but I was not involved in any of the development of the HPOA, and what that means is that I come to it with a sense of, I bring my technical expertise and my experience, and I come to it with the desire to make sure that we're following the law, and that what we're doing, our processes are shaped by the principles I laid out, and particularly that our processes are fair, that they're effective, and that they're efficient. And from my perspective, that they really focus on looking to resolve matters that are in the interest of all the parties in a case and the public. And I'm a big believer in resolutions. A life as a litigator has taught me that hearings and contested matters are the worst places to resolve. They're the worst places to look for restorative justice. You have to do that at the table through honest conversation and through honest engagement. And those are the principles that I bring to trying to put the discipline process into effect. I also I often will say I do wish that they come with a different title. I think that it sends the wrong message in terms of how I see my role, but that is the lot of the statute. So, um, as I'm going to overlap a bit into what Graham said and just lay out a bit what the process looks like. I do think it's important that people understand at a high level the roles of the colleges versus the roles of the role of the discipline tribunal. And this is the key, is that as I would expect, the vast majority of cases are still going to be handled by the college through consent resolutions, through agreement. And the cases that are going to come to the tribunal are only those where a resolution isn't possible, or where the allegations are so serious or of a certain nature that they require a different process. And so I think for most people who are experiencing a complaint or are interested in the process in another way, again, the vast majority of cases are going to be resolved at the college level. As Graham pointed out, complaints come to the college. The college manages the investigation, and the Act creates as Graham referenced, a bunch of sort of supports and some powers in respect of the investigation that should streamline that and make it a little more straightforward. It comes to the investigation committee, and the investigation committee has to decide whether or not that they believe there are reasonable grounds to believe that misconduct has occurred. If they don't believe that, then the case is dismissed. If they do believe it, then in most cases, they can direct the registrar of the college to resolve the case under the Act primarily with the consent of the physician involved. There's some powers to do it without consent, but they're very limited, and the orders they can make are very limited. The exception to this is as any sexual abuse case, and sexual abuse is a complex definition in the Act. Essentially, it is sexual misconduct or sexual touching or an attempt to touch that is done without consent. And those cases where where a complaint alleges sexual abuse, any resolution of those cases requires a sign off from the director. And that's a case where I have to be satisfied that the resolution is in the is in the public interest and meets the requirements of the act. But for the vast majority of cases, they will be resolved at the college level. For those cases where resolution isn't possible, or again where the case is so serious that the college feels it's appropriate to pass it to the tribunal, the college makes a request for a citation, and that request comes to me along with the whole investigative record. The statute says that I am presumed to that it's presumed that I will grant a request for a citation. So in the most cases, a citation will be issued. I have the exception or that, or the considerations I have to decide not to, are cases where there are procedural fairness issues that can't be resolved, that through a combination of something that happened in the course of the investigation or the presence of an identity protection order that we can't mitigate the unfairness on that. Then in that situation, I have the ability not to issue a citation. There are a few other areas that if the matter is being dealt with in another proceeding, or if I feel that the matter isn't serious enough, or that the circumstances of the case mean that it should be resolved by the college, I can send it back to the college to resolve it. And but in the normal case, we would expect most requests for a citation, given that they probably have exhausted attempts to resolve it, most cases will be issued. If a citation is issued, I'm going to try and avoid too much complexity in the process. I can talk unfortunately, for hours about the complexity of the process of the act. If a citation is issued, at that point, I'm required to establish a deadline. And that deadline is sort of the deadline for consent resolution. So there's a window in which the parties can agree on a resolution after a citation is issued. And if they agree, then we cancel the citation and the colleges impose an order. There are some reasons why that may be done in some cases where even the parties may agree on it before they requested the citation, but there are some disciplinary orders that the colleges don't have access to without my sign off. And really, I think the idea is that more serious cases that require some more serious orders, there's just a desire on the part expressed in the statute to have more scrutiny of that. So if a case that period after the citation is issued and until the what we're calling the consent resolution deadline, that period is going to be a heavily case managed period. I will be involved directly in many of those cases, looking for a resolution. We will offer mediation if if that will assist the parties. We will do all we can to get the parties to come together and to agree on a resolution that reflects the interests of the parties and the public interest. At that point, to be clear also that the interests of the complainant and is also something that we'll be factoring into any resolution at that phase. Once that deadline passes, the case moves to our hearing management and to our hearing phase. And at that point, it begins to look more like what we'd say is a traditional administrative law process or traditional tribunal process. It goes to a panel of three. Our panels are required to have a member of the public and to have a professional member who has has the same license, is the same category of licensee as the subject of the proceeding. And we also will have chairing those panels a vice chair who will be someone that is experienced in administrative law and the conduct of hearings. And the panel of three hears those cases. There is still an opportunity to resolve those cases, and we will be supporting resolutions in those cases. The process is different. At that point, in order to resolve a case, it is resolved on the citation. The citation isn't canceled, and it's done by the decision is made by the panel and not by the director. So it's a more cumbersome process at that point. The At the end of a hearing, where if misconduct has been found, the college, the physician in the case of this college, and the complainant all have the right to seek a review of that decision. That review comes to me in my capacity as director, and that review may be a written hearing, it may be an in-person hearing, it may be a combination. It'll depend on the nature. So there is an internal appeal process by which where misconduct has been found. There is no appeal or no internal review process where misconduct has not been found. It's only in a case where there's been a finding of misconduct, where that finding in any order can be subject to review. As was referenced by Dr. Mahal, there's no freestanding right of appeal in the statute. There is a right of judicial review that exists for all people in the court. There is a privative clause, as we call it, that limits that. So that application for review is the opportunity for a robust review of any decision, and we take that very seriously in light of the lack of an appeal and the limit on judicial review. So we're really focused on ensuring that process is going to provide a robust review of any decision that the tribunal makes. The other thing I want to say that when you look at this process and some of the elements that Graham spoke about, and most of this, I won't be involved in this part, so I'm sort of speaking a bit out of turn. But when you look at the process and you look at the decisions that are made along the way, I think that it's pretty clear when you look at it that there's a robust engagement with ensuring that complaints where there's no merit, or complaints that are vexatious, or complaints that are unfounded are screened out of the system. I can say on the tribunal end, like, there's no interest that we have in managing cases where there isn't an evidentiary record that supports a more robust process. I don't, when I look at the act, again, coming from it new, I don't flag that as an issue with the act that's going to change. If anything, I think there are probably greater powers to ensure that cases that are sort of frivolous are screened out. Where there is a significant difference is the publicity of the cases, and going forward, all disciplinary orders, as Graham spoke to, and requests for citations. Those are the two that I'm concerned about, because I have oversight over the information that's published in those two. All of those are required to be published. There is, though, a provision under Section 158 of the Act that allows the colleges to have an order dismissing a case with warning and advice. So that power still is available, and cases that are dismissed under that section with warning and advice are not disciplinary orders and are not subject to publication. So there is still I'd say a very sort of meaningful engagement with screening not just cases out of the system that are where there's no merit. And again, no one involved in the disciplinary process wants frivolous or vexatious or problematic cases to carry through. But there's also this ability that the colleges will have, the registrar of the college will to decide where in a case where, again, my speculation would be it would be a case where it's the 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 allegation is, so this is a case where there's misconduct has been found and it has been admitted to, and there's an acceptance of responsibility, and it's not, I would assume, not a very serious, not the most serious, certainly, and probably a situation where a physician doesn't have a long history of similar or related discipline issues. Those cases can be resolved with a dismissal and warning and advice, and that's not public. And so I think it's really important when we talk about the publicity of the act that we understand that it's not the case that it's definitely the case that there's probably going to be more publicity around cases where misconduct has been found. There's no question there'll be more, but it's not to say that there isn't a significant effort to try or significant ability to ensure that not all cases are dealt with that way. And when you look at the stats that Graham provided at the beginning, I think as he said, I don't think that we're going to see a whole lot of things different. And I think that's probably right. I think some of the cases that are currently resolved through dismissal after misconduct has been found will still be resolved through dismissal, but probably fewer. And I think that's just something that we all have to understand. Next slide, please. Sorry, I'll wrap up. I've got about 3 minutes, I think. So again, my point is the colleges still have a very significant role. By the time it comes to the tribunal, we're dealing with really only the most serious cases, and or the cases that involve more complex disciplinary orders in order to resolve. And we will be looking, even in those cases, to do what we can to further an agreed upon resolution where the parties, because it's, effective orders are orders that the parties agree to, not that are imposed on them. There are just some of the changes in the process that I spoke about. Some from the resolution for more serious cases come to the tribunal. All sexual abuse complaints require approval from the director of discipline for a resolution. More publicity and transparency, as we talked about. The decision on citations comes to an independent body, and we'll be, as they offering mediation, and we go to hearings only as required. All members of the tribunal are appointed by the director. Hearing panels must include one member of the same profession, as I spoke about, and there is an internal review. So those are, I'd say, I'd highlight the main changes, or the main features, at least, of the new process. Next slide, please. As I referenced, we have sort of three categories of discipline tribunal members. We have vice chairs who have specialized experience in certain areas. And then we have public members who have interest and some experience, but aren't quite as specialized. Both vice chairs and public members are public members for the purposes of the Act, but we've sort of specialized a bit the role of vice chairs, which is common in tribunals, to ensure that we have some good and strong senior leadership on the member side. And then we have the category of professional members. So I've ensured that professional members are paid the same as vice chairs. And none of you are likely to retire on the rates that we pay the members of our tribunal, but I felt it was important that The professional expertise of the members is recognized, and so they're paid the same as the vice chairs. And they need to be a currently licensed member of a regulated health profession and with an interest or experience in discipline proceedings. Next slide, please. So currently, we have 9 members appointed. This might already be out of date. We have 4 vice chairs and 3 public members and 2 professional members. Their work has been really supporting our efforts to get ready to help us develop our practice directives and policies and to help us set up a recruitment process. We're looking for a few more vice chairs and public members by April 1. And we have a large project ahead of us, recruiting for professional members. And this will be an ongoing part of our work. And I'm really grateful for the opportunity to speak to you all about the work that we do. We are targeting 10 professional members by April 1 and 20 plus professional members by September 1. When we're fully up and running, we'll likely have 40 to 50 professional members, which is a very large component for a tribunal that is going to have a relatively small case load in terms of hearings. And so that's just a logistical problem they're trying to work out. We're trying to work out. We are actively in the process of building out our merit-based selection process. Next slide, please. And we will be constantly looking for professional members over the next few years. As I say, we're looking for at least 1 member of every regulated profession. But the truth is, for some professions, we're going to need more, and physicians are one of those. I would expect that we would be carrying about 5 or 6 physicians on the tribunal at any given point to ensure that we have the capacity and expertise available to us. They're selected, I say, through a merit-based process. There's a couple of rounds of interviews and then some more informal conversations to make sure that it's really something that where you're interested in and you understand the time commitment. On an ongoing basis, the time commitment is sort of 1 to 3 days per month, but hearings, they can be more complex, and some of them will be as long as 2 to 3 weeks at a time. And the members will have control over their own assignments. We're not going to force anyone to sit on a hearing, and it's something where we'll be managing a lot of notice, so those people who are interested can manage their schedule to the extent they're able to. We will provide training in administrative law, hearing management, and our processes and principles. And you will be, and any professional member on a panel it will be supported by vice chairs, most of whom will be lawyers, all of whom will have a lot of experience with admin law and hearing management. The professional member rates, as I said, they're probably not going to buy any of you a beach house on a Caribbean island, but they are the highest that we can pay under the government's remuneration framework, and they range from $755 to $845 per day. If you're interested, go to our website. There's more information there. You can send in a cover letter, a CV. You can contact me directly. My contact information is available on the website as well, and I'm happy to talk to anyone who's interested about it as well. We're really going to be dependent. The success of this and the degree of trust that we can engender across all the professions is going to come down to the character and quality of our members, and nothing else that we do is going to have a greater impact. So, I'm a member of a regulated profession as well, and also one that's going through some changes to how we're being governed, and I think, like a lot of you, I'm sure feel the same way, that participating in these processes, having a voice and a role in discipline and governance is one of the the public interest aspects of our work. So those of you who are interested, please reach out and let us know. And I think that's all I've got. So I'll pass it back to you, Anthony.
Well, thank you so much. Appreciate all of our panelists for taking the time and giving quite comprehensive explanations. So before we begin the Q&A period, I'd like to thank everyone for providing such an in-depth review. We have about 40 minutes for questions and answers, which means we won't likely get to all the questions we've received. However, there will be an opportunity for Doctors of BC to follow up on key questions that we can't get to this evening. So we also recognize that there may be a lot of questions and concerns related to the legislation itself, particularly the appropriateness and impacts on physicians. Neither organization can speak to the appropriateness of the legislative framework, so the questions we'll be prioritizing today will be those specific to what our guests can respond to. I encourage you to keep your questions to complaints, investigations, and discipline, as we have a rare and valuable opportunity to have this dialogue with the College and Discipline Tribunal. You can reach out to Doctors of BC anytime if you have questions about the legislation and our work related to the HPOA. A quick reminder that please use the Zoom Q&A feature to submit your questions. This feature is found on the Zoom toolbar and most likely located on the bottom of your screen. When submitting questions, please indicate in the question itself the specific panelist or organization you'd like your question directed to. So as we're getting our process and questions organized, Dr. Mahal, I understand you have a question to start us off.
Thank you, Anthony, and thank you, Graham, Benson, and Patrick. My question is directed to Benson. We've heard from the Discipline Tribunal and the Health Professions Occupations Regulatory Oversight Office that you plan to regularly review policies and processes once they're implemented, and that you're open to feedback on them as well. We welcome and encourage the intention to engage in ongoing review and improvement, but could you provide more information on how that will be implemented? Will you have periodic reviews of how things are going, and will there be meaningful opportunities for health professions and specifically physicians to provide input into what's working and what isn't?
Yeah, thank you for that question, Dr. Mahal. It's, you know, this is, I'm going to say this is a complicated act. And my approach in looking at sort of setting it up is to try and approach it with some, I'd say, practical humility, and that in the sense that, we're not going to get every process. We're not going to be able to map out every scenario at the beginning. And so I think of, when it comes to our rules of practice and how we're going to look at case management, both our external and internal facing framework, I think of it as being sort of interim for the first year or plus, depending on how we look at it. So we will be doing robust internal review. We will be reaching out to the colleges and the associations to ask for feedback. We also will we have some performance standards that we will be looking at and reporting on. For me, the transparency about how it's working is a big driver in how we should shape our policies. And I think that it's always hard for organizations to say, "Oh, we didn't quite get it right." And I think that the transparency, the requirement of fairness needs to trump that. So yes, we'll be open to review and comment. And yes, we will do that through specific outreach to the associations and the colleges and other interested organizations and other participants. We will also allow for public. We may not always agree with the comments and the consultation, but at the end of the day, we will listen in a meaningful and robust way to make sure that we're getting things that we're improving our processes.
Thank you for that. Here's a question for you, Benson. Do registrants have recourse for decisions, and will you be recommending any monetary penalties?
When you say recourse for decisions, what do you mean?
So if a decision is taken, is there a manner in which to appeal it?
Yeah, so there is an where a hearing panel makes a decision, there is a right of a review, they call it, but it's a right of appeal to the director. So I don't sit on my involvement with the case ends with our hearing process. So once that deadline that I spoke about expires, I'm no longer involved. I don't sit on any of the hearing panels. I don't conduct any of those cases. Once they're done, there is a review mechanism, an appeal mechanism that we will make robust. We have the ability to charge a fee for that. I'm not going to charge a fee for that in the first few years. We're not even consider it. I think it's important that everyone have access to that and that be accessible and robust. Sorry, the second part of the question was
Monetary penalties.
yeah, the Act allows for monetary penalties, and that is something that will provide some guidance to our members on how to look at that. The Act doesn't say too much about it, but we do have the ability to order monetary penalty. That is not something that the college can do on its own, I believe, although they can do some costs or expenses for investigation.
Thank you. Dr. Rowe, maybe just for members who are unfamiliar with all the jargon, could you or Graham explain the differentiation between bylaws and legislation and in terms of HPOA and their effect and imposition on physicians?
Well, I can tell you for sure I'm going to hand this to Graham, but um, it's very similar, for example, Anthony, to what physicians experience in the hospital setting. So we all know there's medical staff bylaws. Those bylaws didn't rise up out of nowhere. They're created to reflect the legislation that's over and above it. And so when it comes to the Health Professions Act or the Health Professions and Occupations Act, or even back to the Medical Practitioners Act, which when Dr. Mahal said was decades ago, made me wince because I remember being under the Medical Practitioners Act. It's the same concept. And so the government passes legislation, that's the act. The act itself speaks to bylaws that must be made. And so if you go through the act, you can see that there's direction in the act that says the board must make bylaws on certain elements, or they may make bylaws in certain other pieces. So that word may provides a discretionary element, with the word must is a mandatory element. And so those bylaws are directed out of the legislation for the most part and really speak to the next step in how you operationalize the legislation. But I'll let Graham dive into more detail.
And yet that was incredibly thorough. So I don't really have a whole heck of a lot more to say. I mean, the HPOA is the legislation. The bylaws are subordinate legislation, so they're made, and so nothing in the bylaws can exceed in scope what the HPOA says. And practice standards have to be consistent with the bylaws, but of course, in the HPOA, they are actually going to be in bylaw form, so that eliminates any discrepancy there. I will say, because I can't help but look at the Q&A while I'm in the middle of talking, there was a lot of, and thanks, Darlene, people wanting to know what's a citation. And fair enough, because Anthony, you were mentioning jargon, so I'll eliminate as best as possible any mystery around that one. Citation is when a screening committee, which is an inquiry committee or investigations committee, takes a look at the allegations and the evidence and decides that there's sufficient evidence to be able to prove a certain misconduct, and moreover that the charging standard requires that that be in the public interest to prosecute. They can issue a citation or ask for a citation to be issued, and the citation essentially like sets out the allegations of misconduct, or the allegations that, if proven, would lead to misconduct. And then that is, of course, served on on the parties, and there can be there's a live hearing where evidence is called, credibility can be assessed, and parties can be cross-examined with counsel or without if they're so unfortunate as to go and self-represented. But then, so that's sort of in a nutshell what that is. Now I can see why I ate into all your time.
I do think
Can't
I do
stop
think
talking.
I do think Anthony and just in terms of what Graham was saying, my colleagues, physicians who've engaged with me, struggle with all of this terminology, and in their heads, they often think of a complaint as being the same thing as discipline. And they think of misconduct as being anything that has led to a complaint, where misconduct has a very specific meaning in the worlds of the Grahams and the Bensons. And so I really think that um, we do our best to be as clear and as formative as possible when it comes to these terms on our own website. I'm sure Benson's going to be doing the same thing on their website because we do know that it's challenging language for physicians. It's not a space they normally work in. But I would encourage everyone just to remember that complaints are not discipline, and that flow chart that Benson demonstrated for everyone, it's really important to look at carefully because you can really see based on the way he's lined out the process that there is a section there that's the complaint process. And then it may enter into a discipline process, although we know that the majority of files probably won't, which is what Benson was alluding to.
I will say that you've taken a legal dragon on our side, but you guys are crazy for acting. Just
Fair.
I appreciate the explanation. I think it's important to underscore the complexity of this legislation. And I think some of the misinformation that exists out there and the complexity bears out more misinformation. I think it's easy to get confused or misunderstood. So I would encourage both organizations, if you can invest in training or easy to understand modules for people to be educated on the new legislation, I think that would be helpful. So Benson, here's a question for you. What tangible assurances do we have that the new Health Professions Discipline Tribunal will have adequate frontline clinical expertise to fairly evaluate a physician's practice rather than applying a purely administrative or political lens?
Well, I would say, first of all, we would never apply a political lens. That's got nothing to do with the work that we do. There's not a shred of political interference in my work. And if there was, I would resign loudly in those circumstances. So this issue of something Dr. Mahal's mentioned, and I've heard this a number of times before, this issue of how how can a physician in one specialty adjudicate a case for a physician in another specialty, especially if it's a highly technical or subspecialty. I think the question came up, and you know what I would say is first of all, if you look at the cases, the discipline cases that are reported by the college over the past couple of years, I think you'd be hard pressed to find an example of a case that would reach the level of seriousness that would come to a tribunal where this would be an issue. If you look at the past five cases, I believe there's a case where someone was espousing personal religious beliefs in the course of providing treatment. I believe there was someone who was convicted of sexual assault and sexual interference criminally, and the case was proceeding against them. I believe there was another one where someone, these are just the most recent ones, right? There's another one where someone had hired a former patient and then engaged in a sexual relationship with that patient. So I sort of will push back and say, you'd have to convince me in those cases that that any of that needs to be seen through a lens of a specialized medical lens. Now, there are some cases I'm willing to accept where we may be in a very technical discussion about a choice of practice in that case. And in those cases, I think it does come to me to try and make sure that I mean, I appoint the tribunal. I have to make sure that the tribunal members have the expertise required to hear the cases, and that includes the professional expertise. And I have some ability to ensure that in a case where that was an issue, the risk was mitigated. The law doesn't require it. And again, I would push back. I'd say if this is really an issue that Doctors of BC considers to be a practical issue, then go back and look at all the discipline, identify the cases where you can point to in physician discipline where this would be an issue. It's just not, I don't see any. So I do think it's going to be an issue for the complaints in the investigation stage because that's where those cases are dealt with, and those cases are going to be handled by the college that has access to that level of expertise. So I'm prepared to accept. I'm prepared to consider what I can do to mitigate and to identify those issues. But I've looked at this question. I've been asked this question, I think, from my second day in the job, and I fail to see this as being a real issue with the current act for physicians. I do think if you look at some of the disciplines, some of the other professions, it's a little more complex. In dentistry, for example, there tends to be a lot more complaints that are around practice choices, and that's something that we're thinking about. But I'd be very hard pressed to identify cases in physician discipline in this province where that's been an issue. So.
No, thank you for that. And I think that does provide some clarity and insight for the members on the call tonight. So this next question is for the college. Many doctors are concerned that if they make any statements publicly about the healthcare system, that they'll be subject to a complaint. Are physicians more vulnerable to college complaints from health authorities and the ministry under this legislation? And if so, is there a way to safely advocate for system reform as a physician?
I think that one was for Graham.
It feels like a Graham question, doesn't it?
No,
I can kick us off, Graham.
thank you. I appreciate that.
Yeah. I just don't know where to start, except to say that the opportunity to raise concerns about the health system or the care that your patients might need is embedded within the Code of Ethics. The Code of Ethics speaks to advocacy. It's also embedded in both the Royal College and CFPC competencies for physicians. Advocacy is part of your role as a physician. And so it's important to remember that the college currently, but also under the HPOA, includes as one of our standards, the CMA Code of Ethics. So we endorse the Code of Ethics as an appropriate standard to hold physicians to. And so that allows for an opportunity for advocacy, for speaking to health system issues, to raising concerns. I think where physicians sometimes get into trouble is when they go far beyond that role. And I think that that's a minority of times. In terms of ministry bringing complaints, the ministry, in my memory, has never opened a complaint against a physician. They might express concerns I'm sure they do with Doctors at BC. I'm sure they will with health authorities. I'm sure they at times express concerns to me, but that's not about opening a complaint. And I don't remember a time that that's actually happened. I think that the ministry recognizes that's not their role. to be an initiator of a complaint process. So, Graham, do you want to dive a little further into that?
Certainly. I mean, health authorities currently have the ability to be able to make complaints and do. We receive duties to report from health authorities. They're actually required to report on certain issues to us. There are matters, though, of the public commentary that are particularly tricky. Freedom of expression is one of the most jealously guarded of our charter rights, and so it's an area in which, frankly, it's very difficult to tread. But legitimate advocacy on behalf of patients or in relation to system issues is very unlikely to attract any kind of regulatory outcome. Although, of course, everything needs to be examined that's presented to us because we don't have the ability or authority, frankly, to be able to simply reject matters. But everything is reviewed on its merits and in context in which it was made. So every examination is multifactorial and considers the context in which it's made, including the language that was used, frankly, what the context is, and how it was perceived. So, there's a lot of nuance to the work, although I'm sure to people involved with it directly as subjects, it doesn't seem that way. But I can assure you that all of these factors and more are considered, and frankly, these processes are ongoing now. There's nothing particularly new, but it's codification in the HPOA.
I think
Okay.
the last piece, Anthony, I wanted to highlight, and I've said this before, so this is not just for this evening. It's critically important that physicians who are wanting to advocate, and maybe in a very vocal way, they need to be engaging with yourself, with Doctors of BC, because I think physicians sometimes don't understand that all of us, whether you're a professional or not, there are limits on what you're allowed to say. There is freedom of speech, but it does mean you're free to say anything. And I think sometimes in the heat of distress, it can be really challenging to keep an eye on that line. And so when physicians ask me about this, I refer them to you. And I say, you need to speak to the Doctors of BC. They will help you understand how to advocate, how to speak to an issue, and support registrants in staying in that appropriate lane. So I really kind of see this one as a bit of a shared responsibility, to be honest.
Absolutely. And we are happy to support physicians to navigate what the issue is, how to communicate it effectively, and not get into a situation where they have a regulatory matter to deal with.
Anthony, can I speak just very quickly
Sure.
I just want to say two things. And one I may regret saying, which is that the question was, does the act make it more likely that you're going to receive those complaints? And I think probably it makes it a little more likely. Like, I do think that that is a legitimate look at, well, if you've got a new act that scopes out discipline more broadly and highlights these things, it's more likely that there will be complaints of this nature. Is it going to be a significant amount? Probably not. But I think if we're being honest, yeah, it's a little more likely. But I the process that we laid out is, I think, going to be better able to screen out those cases. Like, none of us are interested in handling, as I said, complaints that are vexatious. And when we look at speech, I mean, the tribunal doesn't, we don't adjudicate constitutional issues, but we are required to bring what are called constitutional or charter values into what we do. And so if a case involving speech comes to the tribunal, it's going to be subject to a lot of scrutiny about, is this political speech? Is this a critique of this system in the abstract is not going to result in discipline. But as Dr. Rowe is saying, I mean, that's sometimes in that critique of the system, there's sometimes other comments that are problematic that can cause harm. And it comes down to that question of harm. If the speech causes harm to people, then we're concerned about it. If it criticizes the system, we're not concerned about it.
Thanks for that clarification. We've moved into the rapid round of Q&A. So I'm going to ask for brevity in your responses where possible. I understand, of course, these are complex topics. So this is for the college. Is it true that the public can make anonymous complaints? And we're just wondering if how fair if that is the case.
Yes, but Graham spoke to that in one of the slides. The circumstances that we would grant that anonymity are narrow and are need to be reflected in fair and transparent processes and natural justice.
Okay. Do you expect physicians to continue to see patients who submit complaints? This could be quite distressing for a physician who's dealing with a complaint and continuing to see the patient.
That's, I think, probably directed to me, Anthony.
Yes.
I expect physicians to do their best to navigate a difficult situation. I have seen, including very recently, cases of what were originally serious or egregious complaints where the physician has not only continued to work with that patient, but has landed in a space where both the patient and the physician are back on good footing, good ground, and can continue really important care. And so I think it's contextual. I think it's case by case, but I of course encourage physicians to try and have respectful conversations, and if they and the patient can maintain a healthy relationship, then there's real value in that.
Yeah, that good communication is so foundational. This is for either the college or the tribunal. Has there been any consideration to filtering complaints that are based primarily on personal dissatisfaction? If complaints can be filed without preliminary review, is that fair?
Graham or Benson want to field that?
I don't
Answer,
really
Graham.
know how to parse out personal dissatisfaction. I'd say most complaints are based in personal dissatisfaction with something or another, but there is an appetite to filter out complaints that can be dealt with through early engagement and resolution on that basis with less of a formal process, the kind of thing that would never make it over to Benson's office. They'd have to be not serious, but if it's we get complaints about I've requested my medical records and it's been 3 weeks and I haven't got them yet. I mean, that's a phone call or an email, right? That doesn't involve opening a complaint in a letter writing campaign like it's Victorian England. So we would want to deal with things proportionately.
Great, thank you. The subject of publication of complaints has come up a lot as HPOA has come about in the public dialogue. Can you speak more about the publication of complaints, where they'll be published, and what kind of complaints would be published?
So complaints aren't going to be published.
Exactly.
What's going to be published are cases where there's been either an agreement on the part of the physician that misconduct occurred, or a finding on the part of a tribunal that misconduct has occurred, or in very narrow cases, the investigation committee can proceed if a physician refuses to engage. Very, very narrow. We're not going to see that very much. So it's only cases where misconduct has been either accepted by a physician or proved by in a hearing that you're going to have the order published. And that's so complaints aren't published. The colleges publish, they're responsible for publishing the order, and I'm responsible for telling them what information has to be included in the order, and that information is going to be it's something where it's not going to look too different from what's being published now for where there's an order.
The only thing I'll add, Anthony, and I know it's the quick fire round, is again, this circles us back to the flow chart that Benson highlighted and our ongoing need to educate as much as possible, because the misinformation exists because that blurring between complaint and discipline, right?
Yeah, totally agree. So to the college, Can you go into more detail to explain what's changed from the HPA around the duty of registrants to report colleagues? Are there new expectations versus the old act?
The distinction is reporting discrimination issues, but that would be frankly, we're not talking about slight rudeness, but actually deprivation of access to services based on a protected ground or prohibited ground for discrimination, such as age, race, or what have you. So if there's a doctor who refuses to see someone, and their colleague witnesses this, I think they would have a duty to report that person. But it's going to be a very narrow test, and we'll be certainly giving much more information about what that constitutes.
I would also add, Anthony, and Graham alluded to this, that you could make the argument that even now under the HPA, that there was a duty to report that kind of behavior. It's just that it's articulated more clearly in the HPOA.
Yeah, thanks. For the college, will these processes apply to complaints currently in progress or only those that are opened after April 1st?
All complaints currently in process are going to be transitioned on April 1st into HPOA processes. And some will actually benefit from that because we'll have the ability to be able to dismiss those that we do not currently have that ability to dismiss, and also to deal with some things as administrative matters that currently would have to go through the citation to get to an outcome. So it could be a benefit, but it is a rather massive review of every single open complaint.
That question in particular was asked multiple times. So if you'd like more time to expand on that, I'm sure it's complex to manage this with the transition, those that are.
Can I just speak, since on the transition, is that like the way that it's going to go in terms of the discipline process is if a hearing has started in a case, it continues under the current act, and it doesn't transition over. If a citation has been issued, and that citation, Graham explained what it was. I offered a similar complex explanation to my admin assistant a couple of weeks ago, and she was like, "Oh, so it's like the parking ticket." It's like, yeah, it's exactly right. So once that ticket is issued, once the citation is issued, that that will proceed under that we will assume that the citation was issued under the HPO and it proceeds under the new act. If a citation hasn't been issued, so any case, any complaint that's under investigation, that is all now as of April 1 under the new act.
I hope that's helpful for folks. I know it was on the minds of a few people. To the college, can you speak more about how you're going to filter out and resolve vexatious or frivolous complaints?
Every matter that comes in is reviewed at streaming by multiple parties. I mean, not in a redundant way, but through trying to bring different lenses, legal lenses as well as administrative to them. And matters that are identified at intake as being potentially frivolous or vexatious or an abusive process will be reviewed by legal counsel to determine whether or not they meet the test, absent any kind of a determination on the merits. So they have to be really clear on their face that they are frivolous, vexatious, or an abusive process. And the definitions that I used on the slide are probably as good as I can get, but just very clearly intended to annoy and with no actual public interest aspect to it.
Thanks, Greg.
I think as you heard from Benson, I think it's fair to say that Graham and his team and my office are going to have to evolve this a little bit as we sort of unpack the HPOA and the processes. And it's hard to think of every possible circumstance and situation and bake that into a policy ahead of time. And so I think this again speaks to us being watching carefully what's unfolding, listening to the feedback that we're getting. I can assure you that the CMPA is going to be very, very attuned to the new act and what's happening in this space, as well as with Benson's shop. And And they're going to be taking opportunities to provide feedback on behalf of their clients, the physicians. So I think, Anthony, it's really difficult to answer that and say crystal clear what day one looks like. We know what our intent is. And I also know, much like the discipline tribunal and the director of discipline's office, it's going to evolve over the first little while as we sort of operationalize it.
Thank you for that. Benson, this is for you. Maybe you could expand on a little further around the selection of public members and how they're chosen and determined.
So the selection of our we have the three categories of members, and so the for each of them there's a lengthy sort of review process. We have posted criteria for what we're looking for. It's on our website, and we go through. There's an interview panel of members that does the first interview, and then they do an assessment. I then look at the assessment and the application, and then I'll do an interview process, and then we'll do a more informal conversation to make sure that, some people love the idea of it and want to get involved, but when it comes down to the actual time commitment and work, they are less interested. So we want to make sure people are comfortable with that. So again, a lot of that information is posted on our website, and as we develop more certainty in our process, we'll be changing that as well.
And the final decision on the individuals, is that you, or does that go through central government?
It goes through me. I'm unique in the tribunal world, that I don't need to either consult or just refer to the cabinet or to a minister. I make the appointments directly.
Thank you. To the tribunal again, given the timelines for this process could take months to years, what would happen if a physician were to quit or retire or leaves the province in the midst of the process? I assume it would just continue on regardless, but
Yeah, we can proceed in if someone is no longer a member of the college, or we can proceed in their absence. Again, it's usually those conversations can sometimes help frame a resolution, frankly. Like it.
This is to either, will there be specific resources or support for medical directors who wish to do really their best to follow standards at the facility they oversee?
Um, I think I need some clarity, Anthony. Are we talking non-hospital facilities and diagnostic facilities that we accredit, or are you talking facilities like medical directors working in hospitals and providing them with support?
Would be the answer, I presume, is different for both scenario.
Well, so through our accreditation programs for non-hospital and diagnostic facilities, we try to provide a lot of support to medical directors because they need to be aware not just of professional standards, but the accreditation standards, which are a whole different pile. And so we provide both personal support and also documentary support to medical directors who work in those facilities. I think medical directors in a hospital setting, of course, are part of a medical staff structure and are part of medical affairs. And so we don't have a supporting role necessarily directly with those medical directors. Medical directors, like any other physician, will reach out to the college or to myself for one of my deputies seeking thoughts, opinions, ideas on various challenges they might be facing. But we leave the support element for medical directors to the medical affairs system and the health authorities.
Thanks for that. This is for both as well. Given that you're dealing with individual professionals, not the whole system, how will you strike a balance between upholding standards while acknowledging that registrants are operating within a system that doesn't often do their most to meet those standards? So they don't have enough support to meet the standards. So how is the individual physician left to be held accountable? I think that's something that physicians often struggle with.
I don't know, Benson, do you want us to start on that one? directed at both. Graham?
I think plainly it's context. Everything is judged within the context. Any standard of care, any standard of performance is judged by the context in which someone is caring or performing. And so that happens individually, situation by situation. No two being the same, frankly. It was when we were asked during COVID to make certain promises in relation to lower expectations for people in certain situations. It was like, we don't have to do that because it's already baked into how analysis is done. How you're able to perform a task is informed by all of the factors surrounding you. So that's already a part of procedural fairness and frankly, judicious decision making.
I think very quickly, again, if you look at the cases that make their way to more serious cases, we're often dealing with conduct that is really clearly not a question of trying to meet a standard that's unmeetable or unsupportable. But in those cases, if and there may be, for me, that conversation, like that's the start of a conversation about how do we resolve this without going to a hearing, right? Like that's that we frame and we make sure that the resolution of that case reflects that, right? And it's like this is at the core of what we're trying to do is to think about restorative justice through this. But restorative justice starts with an acknowledgement on the part of the subject of the proceeding that they admit what's happened, that they accept responsibility for it. And that can be shared with the system. And we need to understand that to craft a good resolution. So what I hear when I hear that question in that context is I hear a situation where we should be mediating this case because it sounds like this isn't a black and white case where it's someone has done something wrong in so clearly outside the scope of behavior, but it's someone in a context where they may have to take some responsibility and the system might, and the order should reflect that. So.
Well, thank you, all of you, for taking these questions and your presentations. Thank you to Dr. Mahal and our guest panelists, Dr. Rowe, Graham Kierstead, and Ben Cowan, for your time and willingness to participate tonight. As a reminder, the recording of this webinar will be made available in the coming weeks, and additionally, new updates and information on Doctors of BC's advocacy efforts related to the HPOA can be found on our dedicated HPOA homepage. The QR code on the screen here takes you directly to that page. Lastly, I'd encourage you to take a few minutes to provide us on your feedback through a post-event survey that'll pop up following this webinar. That helps us inform how we do these meetings better. We appreciate your time tonight. Thank you and take care. Good night.
Thanks, everyone.
Thank you.